I'm Dr. Barry, licensed psychologist, and here I share legal and entertainment news from a psychological perspective. Thank you all so much for joining. I really wanted to talk about Sarah Boone's potential defense that came up during this hearing. I am going to zoom through portions of this hearing. Many of us have already watched it with Laura Reese. So I have some links to some lawyers covering this down below. I also have the Lawyer You Know's coverage of this. And I did also check out Uncivil Law's coverage too. And so, if you want a lawyer's perspective, please check out their channels. Today, we're going to dive into some triggering topics. And so, please, if it's not a good day to have this type of conversation, come back to another video. But we are going to be talking about DV and one's is it interpersonal harm or is it mutual harm? And with this case, I do have a little bit of a bias that I will disclose because I just can't get over the callousness in the video that was recorded on Sarah's phone. And the story from the start did not make sense. And if Sarah had started this defense from the very beginning and not done all of these things, I really feel like this is a Hail Mary trying for anything. This was the only potential defense. You can't say it was an accident. You can't say any of these other things. And every person deserves a decent defense. I am so interested in hearing the expert testimony in this case because I do think we are going to have some licensed psychologists or psychiatrists that are going to come in to talk about DV and some of the effects. Can any of this describe or justify or explain, help us understand her behavior? And so let's dive into the first part of this hearing. And so when I first saw this first part of this video, I did think that she was making faces at the camera, but the lawyer so that's where lawyers have to be more balanced. He did make a good point. She might have seen somebody that she recognized. So there might be somebody that she's smiling at. I do not know. I don't know if there is anybody sitting over there. I wish whoever was the camera people that were in the room, I would love to know, like, was she making these faces at the cameras or was she actually looking at somebody that she knows? But she starts off looking very pleased with herself, very pleased with her case, and yes. So that's where I got some of the screenshots for the beginning of this. And so she could be looking at somebody, but it also does seem like she's looking and making faces at the but she could be looking at somebody. I don't know. I don't know. Because to be on trial for what she's on trial for, now everybody deserves to laugh. Everybody deserves to be happy, but what in my opinion, what she's putting George's family through, like, this is it rubs me the wrong way. Let me know your thoughts in the chat. I was very perturbed by this. And I think I was in Laura Reese's because now I think maybe somebody came in that she doesn't like so much because now she's making other faces. And this is where I say that Sarah Boone comes off emotionally immature to me. To me, this is how I would expect a teenager to act in this type of situation. This isn't what I would expect from somebody that's in their 40s. So Sarah is older than I am. I think she's because when all this started, I think she was 42, and so, because she says her birthday is 77, like, Sarah is is an adult, but there are times that she just acts very juvenile to me. Those are my thoughts. All right. It gave me just rubbed me the wrong way. This look is gonna be very different towards the end of this. And the cameras are going to zoom in, the cameras are going to, like, play this up a little bit, and so alright. Ugh. All right. So the judge is going to start out with just setting the record. And before he even acknowledges her attorney, he's going to ask about the deadlines that they had already set. And she's going to say that yes, she did review the discovery. Let me see what setting. Okay, so we'll try it on 1.25. I'll slow it down if I need to.
August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much.
And so the fact that that happened, because this means that we are on track with how things are going to proceed. And this judge, I hope that this judge teaches classes, that he speaks at law schools, that he helps train future attorneys on how to set boundaries with clients, how to set expectations for judges. How do you just make sure that defendants don't end up using things to their advantage, and then we're undermining the victim's right for swift justice as well. And he's going to make a comment at the end that I am going to try to make sure to include too.
Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed on August 14th. The next day, August 15th, JSC has filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously.
So there's a forensic, I think so. I think he said a psychologist. Let me back it up just so I can hear. I was in the comments, me and let's turn these on.
Adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist.
So a forensic psychologist. And so those are psychologists that are specifically trained to come in to understand the law and psychology, and to provide opinions in criminal cases. They receive additional training. So I am a clinical psychologist. Dr. G explains, and Dr. John Dr. John is from Hidden True Crime. Dr. G explains is another channel. They are both forensic psychologists that work with court systems, they either currently work or have worked in the past in jails and in jail settings.
Dr. Julie Harper, who was on this case previously, I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend.
4 or 5 times. So me as a therapist, like I'm just thinking, like this lawyer is coming in at the last minute and like why are you messaging? But it was fine. Like this is to hire somebody for a position. This is likely something where the person is going to receive between $200 to $400 an hour. They're going to come back in and take a look to see if there is if she meets criteria for battered spouse syndrome. So go on ahead and hit that like button if you are here. Let's go on ahead and keep going.
She is in agreement to handle the case to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, I hope that she's going to be of that opinion.
So it sounds like the doctor hasn't formed a final opinion. It looks like he's just looked at the records and that a final product, it doesn't look like a final report was ever made or that a final opinion specifically about battered spouse syndrome, it doesn't look like that has come into play yet. I would think that the individual could probably meet with her if they've already met with her 6 times. I'm thinking they could probably meet with her 1 to 2 more times. I wouldn't think it would need to be that long, and so there is a possibility that they could proceed with this October 7th date.
In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berglund, who is from my area, Pensacola.
And so he's asking for a crime scene investigator to recreate everything. Okay.
Is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berglund. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did.
And then they're going to go back and forth to figure out what's happening with the files, and really this is going to be up to that neutral, like to that court system that approves whether things what the funds. So they have to see, they're going to have another hearing to decide if these additional experts are going to be able to be paid.
ACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed.
So they're going to try to work that part out. I would like to point out, so I was really concerned if Sarah Boone was representing herself, that if, let's say, some of George's family was going to come, because so I think the last person George spoke to, I believe, was his brother. His brother talked to him on the day that that night, and so if his brother came in to testify, I remember with the Darrell Brooks case, I felt so bad for those victims, those survivors that he had to cross-examine, or the people he called, and he was very erratic, he was all over the place. And then with his ex-girlfriend, I think at times that I was so proud of her that she stood her ground. She was able, like, she kept it together. She gave her testimony, but that had to be scary. And so I do like the fact that there is an attorney that stepped up to kind of fill in that gap. And then so some people have made comments about her seeming, so to me, I cannot diagnose her. These are just my general thoughts. The thing I will tell you is individuals who are covert narcissists sometimes use flattery and charm. It's not that they really like the individual, it's just that they're using flattery and charm to try to manipulate, to try to get people to do what they want, to try to be likable. So in my personal opinion, when Sarah Boone, when she doesn't like what you're doing, she can flip. And then you see the other side where you get a 18-page letter, alleging that you've done unethical things and going to every side, like talking bad about your character. And so I do just want to say that I don't know, I think she uses that to try to get people on her side. And it's not in a histrionic way, in my just in my personal opinion. So individuals like Amber Heard, in my opinion, my personal opinion, and I think Dr. Curry gave this opinion as well. Amber Heard would try to use, like, her beauty, her charm to kind of get people to like her. I think Sarah Boone, I think she just tries to show that interest. This guy is doing this for free. And now he's agreed for whatever reason to do this for free, but those are my concerns with that. Thank you for gifting a membership. We will see who ends up getting it. My membership is continuing to grow and evolve yeah, so that's what I'll leave that there. Um, and that's where I think some of that emotional immaturity comes out, where she tries to play kind of, I don't know, but it flips. And so that's where it can be kind of cutesy and small, and then it can get, in my opinion, it can get kind of aggressive sometimes as well. All right, let me see if this is a question. My feathers got very ruffled when he suggested, yes, when he brought up the Marcia Thompson case. Those 2 cases are not even comparable. She was truly a battered spouse. Sarah participated in drunken mutual, in which she was probably the aggressor in that moment. She was definitely the person that had more power. It is really hard for me to think a jury is gonna see that she was com once you see that tape, how do you not see, like, malice, depraved heart? Now, even if it's because, he treated you wrong. Okay, let me just try to fix my camera. So I have it swivels, it tries to follow me, so I've been trying, here we go this way. I'm gonna try to fix this real quick. Alright, there we go. Yay! So did you end up getting it? Awesome, awesome. Um, I don't even know. I thought he was tall. Is he a tall person? In the pictures, he looked tall. I don't know if he was. Um, welcome, welcome. All right. So let's keep going. Let's see. George had 0 DV charges prior to Sarah. And I wonder, so the hard part when a defendant goes on trial, I think her lawyer will try to keep some stuff out. I think her lawyer will try to keep, but his family might be able to come in and talk about how things changed, talk about their toxic dynamic. I believe there are police reports that talk about, them both having marks at times. And at one point, because she was arrested when he said that so almost the part where he could not breathe. So that happened on one occasion. I have that video teed up. Court TV did a review of some of their history, I think from a year ago. And so I will do that. I just want to point this out. She was laughing. And then her behavior after the fact was saying it was just a game. We were having a good day. But I don't know if she was trying to say things so that they would just let her go, that they would believe it was just an accident. This was just like it was unintentional. I didn't mean it. And so that they would not press charges. But then she gave him access to her phone, and I truly believe she did not remember what that she had done that video. I don't think she remembered. And we're gonna talk about alcoholic blackouts as well today, because I wonder if the prosecution, if their expert is gonna talk about alcohol and memory, are they going to bring any of that up? Because she sounds intoxicated in the video to me.
Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
I'm gonna fast forward a little bit. So, all right, let's just see from here.
In the building?
Yes, it's in the courthouse, right there.
So they're talking about how they can get the evidence to the defense, and he just needs to stop by the prosecution's office, which is right there in that building, in that courthouse, to with a flash drive so that he can get the evidence that he's looking for, the digital evidence. Now Sarah should have been able to give him her copy. She probably wants to keep her copy. In my opinion, Sarah comes off controlling, and so that's how I see things. Miss Boone's attorney said it's not pro bono. He specifically stated she owes me. I didn't hear that. So everything I saw, because he told the judge that he was not being paid for this. So that's what he told the judge. So I don't know about that. All right. And we're not going to show the video today, but just trust, if you haven't seen it, it is traumatized. Like it is a lot. It is a lot. The jury is going to have to watch that. The defense is probably going to try to see if they can get it thrown out. If there's any legal reason to try to get it thrown out, I'm sure the defense will try to. Perfect. I thought so. It's he was 5'2"? He was only 5'2"? 103 pounds? Wow. I don't know why every video, everything I've seen of him, it made him look tall. I was not aware. Everything I saw of him made him look tall. That is very interesting to me. Because I wonder if the defense is going to try to portray him as this big, you know, this guy that was so, their words would probably be like aggressive or something. And it doesn't seem like that's what was going on at all. It sounds mutual to me. And Sarah's ex, so Sarah Boone's ex-husband, has said that when she drank, she would get aggressive towards him and that he would have marks from trying to protect himself. And so, um, and even though, so a person can weigh more than a person and the other person still be stronger, but it does to me, I don't know if I was on the jury, but like I said, I could never be on this jury because I've watched too much of this coverage. I've already formed a bit of an opinion, and so yeah, those are my thoughts.
Come out front door, main left.
I don't have a USB with me, but I'll find one, this morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state you the opportunity to review this.
I just reviewed it just now here in court this morning. The state is going to request an opportunity to respond to both this motion and also the motion to the statement in particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for?
Okay, so these are my thoughts, my opinions. That's why y'all come to my channel. My thoughts, my opinions. In this moment, I think Sarah feels like she's winning. Because if you go back to her ad that she put out, that this guy supposedly saw, her ad was like, you have to be up for success. And I think in her mind, the only successful outcome is not guilty. When really she should be looking at, is there a chance I could maybe just get manslaughter? Because to me, legally, I personally feel as a non-lawyer, I feel like second degree would be, because I would I think the prosecution just didn't have enough to charge first, because it didn't seem like it was a plan, like a planned out thing. It didn't seem like she had been Googling, what happens if you leave someone. It doesn't sound like there was any planning that happened with this. And so I think that's why the state is going with second degree. Tanika, welcome, welcome. I have loved your coverage. I'm so glad you were able to take care of your baby. I think it was yesterday, your little one on your stream. I adore your channel. All right. But okay. So she's not going to look like this towards the end, because in this moment, I think she feels like she is winning.
Statement particulars and the motion for additional discovery.
I would ask for at least a week.
Any objection?
Go ahead.
Okay, all right. The state shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business.
And she's also very glad to have an attorney, because she clearly needed one. She was not going to be able to do all of this on her own. She desperately needed somebody else to help her out with this. She did not know. And her attorney, James Owens, is very he's very, like, he has a lot of experience, and the judge is going to quote some of that when he says, "You accepted this case? You dug this hole? You are in it." And I adore this judge for this. All right, let's keep going.
Business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs, appointing
I truly think she was hoping that bringing somebody else on would extend things. And I wonder why this attorney did not file sooner, because he could have been on all of this stuff because he's met with Sarah 4 times. So if I was the judge, it would have been like, you've met with her 4 times, so you've already got going. Like, yeah, sure. Like you have plenty of time. Not a lawyer. Yes.
Psychologist to assist the defendant in preparation of the defense. Court can deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, state, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today, so that Ms. Barrios can reach out to JCS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectively.
Judge, I'm going to want to add one other forensic.
Before we get into him bringing up that other case that we've briefly mentioned so far. So it's my understanding that CPS, y'all correct me in the chat if I'm wrong. It is my understanding that CPS was called because she had put her son, like jokingly, she had put him in a suitcase, and she was warned of the dangers of that, and that was not safe, and you should not do that. So prior to this incident, it is my understanding that she had had an incident with her son. And so, yeah. And that's just so that's where some of that juvenile stuff. So I honestly, I don't think she meant for George to die. I think she meant to cause him some pain. I don't know that she intended, but the recklessness of her actions led, because he said, "I can't breathe." And she laughed and did nothing. And she went upstairs and went to bed. And she's gonna say, oh, well, and I think in some of the interviews or somewhere she said she thought he was able to get himself out, and he wasn't. He wasn't able to get out, and that's where he yeah, so we're about to get into that to the other expert that they wanted to bring in.
Psychologist.
I personally do not think they're going to be able to bring this individual onto this case this late when they've already had multiple other experts that have already been involved. Because this expert was able to successfully get, so excuse me, a jury found that the individual was a battered spouse, and they found them. I don't know if it was not guilty, but I think that was the gist of it. The individual, I believe, was found not guilty, but he's going to explain it.
Make a request. I want to make sure that there's not an issue about my client Sarah Boone on manufacturing defense. And there's a second doctor, Dr. Michael Rand.
And so he specifically said, I want to make sure, like, nobody says we're over here just trying to manufacture a defense like that. Yes, this is legit. She actually has this. And so that's what they're trying to say. And so they wanted to bring a second expert on.
Dr. Michael Brandon.
Brannen.
He spells it Brannon. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year.
And that individual, so she had a documented history of there was severe harm with medical records, all of those things. That was a very, very difficult, that was a very, very different case. Very, very
Year, that was a 2019 case, and that took a while to get to trial. But Dr. Brandon testified that battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
So that is true. And so even individuals with complex trauma, they can also, because what trauma does to the brain is sometimes it can leave the I'm in danger signal turned on. That is accurate. And I personally also feel that in this moment, it was more of a vengeful act, in my personal thoughts, in my personal opinion. I don't, she might have felt safer with him in there, but I don't, she went to sleep. Like, so are they saying she knew he was gone before she went upstairs and went to bed? Because she went to bed and then expected to find him alive the next day. Like, what? But I'm interested to see how this plays out, because there are a bunch of holes in this that I'm not sure how the defense is going to try to close any of that. It's also very sad with her son, because it's my understanding that George was the one that would play with him outside. George was the one that kind of paid attention to him. If you watch some of the testimony of the apartment manager, not testimony, but the interview with the apartment manager, you will hear that they often found her son just playing outside all by himself with no adult supervision. And that was very common, that they really never, if they saw Sarah, she was often intoxicated. Like, that's just how they saw her. They had been warned multiple times, George and Sarah, about because there had been complaints, the police had been called, there were all of these issues at the apartment. I don't think it was one-sided. I do personally think that it was mutual. Um, and when I say mutual, I mean that I think they had a dynamic where they could escalate, and both, and yeah, and things get where, yeah, things get problematic.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need at a point for a forensic psychologist.
If you would like the videos without my interruptions, I have the links for them down below. So I do hope the judge has made it very clear that she can't fire this attorney. That this attorney, that, because I think once she feels she's not winning, it's my understanding that Padilla was fired 2 weeks before court, or like he asked to withdraw 2 weeks before they were supposed to go to trial. And the judge is going to point out he never filed anything saying they were gonna go with a self-defense, not a battered spouse defense. And so, so
Two forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And in addition, I would like Billy Lane, who's seated in the audience, he is the investigator on the case. Because of the claims that we're making, she's a battered woman. We need evidence to corroborate that. So there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands. So it's going to be some.
So he's going to have a list of issues that he potentially sees with all this, and the judge is just going to sit there and listen. The judge is going to listen to every single issue he brings up, and then is going to talk about the fact, so that there have already been funds approved for the private investigator. He hasn't used all those funds, and so the lawyer just has to file something so that the investigator can continue to work.
for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs. They've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. It is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact.
Okay, so he's listing all of these issues that they have, all the reasons why. The state is going to then come up. So let's listen to a little bit of the state, and then we're going to listen to the judge, and then I'm going to talk about battered spouse syndrome, and because it can also be considered intimate partner violence. It depends on the laws in that state, and in the state of Florida, it sounds like it's called battered spouse syndrome. So we're going to get into that, and then also alcoholic blackout in just a little bit.
Defense?
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys. And in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse.
I don't think the state is thinking through this. Did he roll it? I would have rolled my eyes a little. Like I wanna see his reaction to that.
Either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week.
He controlled. I could not be a lawyer. Who? So I have testified before, and I do have to breathe. I do have to manage my reactions, especially because normally I'm asked to be there by one side. And whenever the other side starts asking questions, I have to like, because they're going to ask me ridiculous questions. Like if they're going to bring up ridiculous stuff, they're going to try to get me to agree to something or admit to something. Sorry about my camera. It keeps so I'm trying a new layout, and it keeps going because I have a 360 camera where it automatically adjusts. And so like it's not staying where I want it to stay. Just stay there. Stay. Don't move. Don't move. So hopefully it'll stay there. We'll see. But the state to me, he managed his like I couldn't see that he was a little annoyed by that. If he was. Like this defense attorney is just trying to do his part. It looks like the state is prepared, very prepared for their portion. And if this other person has met with her 6 times, that person could likely provide what their preliminary results are. They could probably meet with her sometime this week and have something to the attorney by hopefully Friday. The attorney has to work all weekend to maybe have something drawn up by Monday. It seems like it's possible. He's not going to have that second expert though. There's no way some expert that hasn't touched this case is going to be able to come on, I think, before even the October 7th court date.
I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week that the time is expired. If the judge doesn't continue with today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist that makes that claim. I just can't say, hey, I'm going to rely on it. And I'm putting you on
I think
notice.
it's understood.
I got to have some kind of authority. I'm not an expert.
But I wonder if what Dr. Harper already assessed for was more general trauma. I don't know if they already assessed for battered spouse. I don't know. It is filed under seal. We will see. Oh, the second expert was on court today. Okay, I might try to see if I can find that. All right.
I think she needs the criteria, but I'm not a psychologist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. Say anything else?
No,
All right, thank you very much. All right, Mr. Oaks, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflict out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what you were identifying, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert. And as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 2207.
The judge not only came with the dates listed, nobody can tell me this judge wasn't prepared for a potential continuance. Okay. This judge was very much, because he's coming with state law now. Okay. Like Judge Kraynick, like this way. Okay. It's reverse on my side. So that's why. So Judge Newman was one of my favorite lawyers before this. Judge Kraynick might be my favorite lawyer. Like, he might be on my top lawyers. I think he might be number 1 because he does this with no emotion. Like he does this just like, hey, this is what I said. This is the law. This is all that's been done. Like he's coming in with the receipts. Okay. So, and I did find the video with Michael, with Dr. Michael Brannon, which means that he will not be able to testify in this case. I don't think. Like if you come on court TV and give an interview talking about a case that you I don't think they're gonna call you. I could be wrong, but I don't think they will. Let's We're almost done with
Third,
this.
1152 and 1176. Barbara v. State 221, Southern Third, 562 at 569. There's a two-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern Third, 1277, at pinpoint 1281, by the 4th DCA 2011, citing to Lawson v. State, 84 Southern Second, 540, also by the 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos' previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role to shorten the preparation time for trial, as set forth in the court's June 28th order. This case is already continued.
I just want to clarify. He said Miss Boone has played a prominent role and why we are here. Like why you don't have the time you need. Like Miss Boone has played an important role in this. And so
16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial on her 8th attorney, Ms. Cashman with Giroux. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice.
the right to the effective administration of justice. The right to the effective administration of justice. Like I want that somewhere because we have to balance this. Yes, Miss Boone has rights. And then also what about the rights of the people who have to testify? So people have already probably taken off of work. So subpoenas, like we're talking about October 7th, subpoenas have likely already went out to witnesses that they know are coming in. Like so because if I have to testify in a case, I normally am subpoenaed 2 weeks to months before that date so I can set that aside on my calendar. Now I can be subpoenaed the day before, like really close to a trial, and I would have to show up, but that causes a lot of issues with my clients, with my, it can cause issues. So normally attorneys try to provide you with as much notice as possible. And justice for Jorge, for George. I think that's how he said it. Justice for him. Like that's what we need. And the taxpayers. Exactly. The amount of experts that the taxpayers have already paid for, it has to be a lot. And so let's go on ahead and finish this up. We're almost done with this. And then I did find the court TV, and we're gonna blind react to that. I have not seen this statement yet.
As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Banquets, Thompson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those
Only has herself to blame.
motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, is established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986. With a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome of defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the estate, 311 7 3rd 185 and 189, 47 DC of 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th. We will have pretrial.
I don't think she thought this was going to happen. I think so. It's always worked before. This is the first time. So her losing counsel, I don't think she thought he was going to hold to it. And I don't think he's creating, I'm not a lawyer, but from everything I'm seeing from the lawyer from every other lawyer, it doesn't look like she's doing or saying, like he is, the judge, he is preserving the record for why he's making these decisions for, like, it has to be extraordinary. But like we're talking, you know, an attorney has like a major, like something major, like the only for a rare situation, this is proceeding forward. Because some people even said, okay, they extended the case 3 weeks. Could the judge just, because it's probably going to take 2 with her actually having a lawyer, they're probably only going to need about 2 weeks. So could the judge just push it back a week? The judge is saying, at this point, I don't have a good reason to. Now, could he decide to later? Sure, he might. He might. But this attorney is going to have to come with a very, very valid reason and not just a hypothetical, I don't think I can get this in time. Like he's going to have a valid reason for this judge to extend any more time.
The pretrial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple things. Number one, I have full practice. I've got the docket day this afternoon in Sarah County for Circuit Judge Scott Duncan. I've got 12 clients. Okay, I've got to be perfect, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear my Zoom?
Thank you, Judge.
No, Your Honor.
And so the attorney is going to be able to attend virtually, which I think was fair. Like this judge set a phenomenal standard. Let's go on ahead and skip ahead to Court TV. Like we have, and I will share this full link because I am going to skip over. They're going to start out with some other. So they have an attorney on. I've seen her on Court TV before, but they have the expert. So let's hop in here.
In jail already. And he says during the meetings, they discussed exculpatory evidence on her phone, which they hope will potentially corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial. Your expertise really shined. Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba, too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her, I don't know that much about the case, but attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background.
Or if she comes in saying, I'm the victim that the state can possibly, so this is where I'm not a lawyer, so I don't know. I would think if she's trying to claim that she was the victim, all the stuff against her I would think would come in as well. I would think. Or her potential alcoholism should come into play. Her past behavior with her ex. Because of the two people, It sounds like Sarah Boone is the one who has a history of being aggressive in relationships. It doesn't sound like George was the one with that history. We'll see.
She may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen court TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to her case.
Appreciate that, Dr. Brannon. We know in one of the motions that her new attorney filed, he said that he's looking for additional discovery. And of course, that caught our attention because we're thinking, what else is there? We've been talking about this case for years. Melba, as you know, you've given us analysis for years on this one. What else could possibly be there? It seems like Sarah Boone is.
And so Sarah thinks that something might be there. I don't know. She doesn't always tell the whole truth. That's my nice way of saying that sometimes the facts and what she says do not line up or match up. So where do we kind of stand with this? My thing is following me again. So I'm gonna try to make it stop. Stop. All right. Oopsie, wrong way. All right, let's get back to this.
Is hung up on discovery, quote unquote. We've seen her, there before the judge saying, I'm not being given everything. I'm not being given everything. And, looking as a spectator, someone who's on the outside. I'm not part of the case. I'm not the prosecutor. I'm not her defense attorney. I'm just scratching my head because we know there were two people at that house that night, the two of them, when this happened, and she created the most incriminating evidence by filming him and not letting him out of the suitcase. Melba, do you think this motion could have teeth? Do you think this is a formality? I'm curious your legal opinion on why this attorney would say he thinks.
Okay, so we're going to skip the legal opinion because I just want to hear from the good doctor. All right.
Insulting. Would you kind of take us behind the scenes? How would that go?
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there a pattern of abuse? Was it ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try to get help? And did she make other attempts to try to get away from the abuse? And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case.
Exactly.
Usually the actions are impulsive, they're quick, a quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse defenses.
Mm-hmm. I appreciate it, Dr. Brannon.
And normally in those types of defenses, the person in that moment, they because it's something that happens in that moment. They are extremely scared and they report it to the police. They immediately say he came at me and da, da, da. Like they immediately say what happened. They immediately report. They don't say we were having a good day. We were doing puzzles and playing hide and go seek. I zipped them into the suitcase, which is not how hide and seek works. I will never ever get over the fact that it was called hide and seek. If she said, so at one point, so she said 50 million different things. So she gave a lot of different versions of what happened. I think on the 911 call is I think where she said I zipped him in, and that one was probably the truth. That's the thing that makes the most sense. Um I don't know what was going on with them in that moment. I don't know what was happening. I know that he wanted out of the suitcase and she refused. And I think she forgot about the video. And the way that she talks about her next day is she's like, "Oh yeah, I woke up, I woke up, he wasn't in bed and I went back to sleep. I saw these missed calls from my ex," because her ex was calling her being like, "Are you going to pick up our son today?" And then she ends up finding him, and then she calls her ex. Do we all know this? Do we all know that when she found him, she did not call 911? She called her ex. And he was like, "You need to call 911." And she called. his interview, his insight, I thought was really telling.
So, in terms of what we may see today, Melba, as we go into the courtroom,
All right. So remember, I don't want the legal analysis. I only want to hear from this expert. I wonder, I bet you he didn't know he was going to be name dropped. We'll see.
Abuse, and does the evidence show that she's tried other methods to try to escape from that abuse? And remember, these are difficult offenses, and the reason why they're difficult
I think I already play that part. Did he say that part twice? Okay. I'll just let it play. See what
is you're asking jurors to not believe what they see, but to really believe what they can't see, which is what a person's thinking and feeling. And the attorneys in this case, with their evidence, have to be able to show what she was thinking and what she told other people, and not just what she did, but what she didn't do. All those things are very, very important in establishing a battered spouse syndrome case. And this particular case, if she hasn't shown those elements, it'll be difficult to get that forward with a jury.
appreciate it. Excellent insight from you both.
All right. All right. So I thought a stronger opinion was given, and it looks like there wasn't a stronger one given. And so, all right. So that's that part. I told y'all that we were going to talk about. Whoopsie. Did I stop sharing? I did. Nope, I did. Okay, I shared the right thing. I'm going to make myself a little bit smaller so that we can see this a little better. And I will zoom in. There we go. So let's talk about alcohol induced blackouts because they are real, and alcohol misuse can prevent the hippocampus from consolidating memories. And the hippocampus is where long term memories go. I love the movie Inside Out because the way that they talk about the ways that memories are stored, they give an accurate portrayal of what happens when we sleep. That's when things kind of truly get stored away. We do have those core memories that can form aspects of our personality, but alcohol misuse can prevent memories from being stored. And what an alcoholic blackout looks like is that somebody looks wide awake. They look intoxicated, but it can be a form of complete amnesia that can span hours, and the person has no memory of what happened during that period of time. And what happens is the blood alcohol, it ends up stopping those memories from getting stored into long-term memory, and they truly do not remember what happened. There is a difference between a blackout and passing out. So blackouts, the person is still awake, but their brain is not creating new memories. And that is an individual that is drinking to excess. Okay. I told y'all that I did alcohol research when I was in college, and a part of that research, we would teach college students how to like get to the pleasure zone and stop. Just like where you're feeling a little good, but then stop. That when you're drinking to the point that you're throwing up, that you're having all of these symptoms, that you're blacking out, that can cause additional issues. People who have had blackouts in the past, sometimes, so I'm not a medical doctor because this is a medical condition, a neurological condition. I would be interested to see if any of this type of information comes in, because to me, this explains what happened that night. I don't know if Sarah was fully, now she's responsible for anything that happened because in state of Florida, if you voluntarily ingest a substance and you do a crime, you're responsible for that crime. Because she had no memory the next day. Unless she's just really in denial and protective, unless she's keeping something back, to me, this makes more sense. And one of her attorneys wanted to do this defense, and it's my understanding she said no. She does not want to be portrayed as an alcoholic. She does not want to say that she has had an issue with substances, despite having a pretty extensive history with alcohol. That, like, it's my understanding it got worse after their son. It's my understanding her behaviors and everything got worse at that time. Um, And that's where, like, did they even do the puzzles? Like, I don't know if any of that was true because so individuals that have, that are alcoholics, they will often lie they'll often be compulsive liars and possibly pathological liars. And I think she was trying to make herself look good. It's my understanding that there was a big argument the night before and things weren't great. Things weren't fine. It's my understanding there was a really big argument. And so I don't believe that we were playing games and doing puzzles and we just had this calm evening. I don't believe that at all, personally. I will never get over her, "It was a good day," because she kept saying it over and over again. It was a good day. Like, we actually had a good day. It was Brian, her ex, that brought up the history of domestic violence between them. Um, and what a potential blackout could get her might be manslaughter. It might not get her not guilty, but it might get her, you know, but yes. Alright. And she did. So I think at some time that night, she called Brian, and I wonder if she even remembers calling him. I don't know what he said about that conversation. She's desperately wanted somebody to say it was not intentional, but now with a battered spouse defense, you're often saying, "I was so afraid for my life that that's what led me. I was in fear, so that's why I didn't let them out." But that's not what she says. What she says in that video is, "You all the things you've done for me, like, this is to get you back for all," not those aren't the exact words, but the gist of it is, "This is to get you back for all the ways you've hurt me, all the things that you've done for me." Let me know if you all have any questions. I have just a few minutes left tonight. Thank you to any new people viewing. Make sure to hit the like button. It just helps the video and the whole YouTube algorithm thing. I'm Dr. Barry. I'm a licensed psychologist. I have a whole playlist on Sarah Boone. I have all of the previous videos linked. Hey, Special K. The reason some of the attorneys left is because psychologists said it wasn't this. And I don't know if that would be a reason to leave, to come off, or unless she wouldn't accept that. Because if she wouldn't accept that and wanted them to find somebody that would, and if she was unwilling to entertain any other possible defense, maybe. I personally feel that it was potentially mutual. And so I did say that I would share about battered harm. And so it was a term developed by a psychologist, Dr. Lenore Walker, in her 1979 book, and was described a person living with a harmful partner. And often with this type of defense, it can also be called intimate partner violence. That is what the American Psychiatric Association calls it. The battered woman and battered partner, often people view that as being a woman. And so intimate partner violence seemed to be a better way of describing what was actually happening. And so you'll also hear people research and look into that, but that it could contribute to learned helplessness, and it can make it more difficult for individuals to in those harmful situations. There can be that tension building, harmful phase, and then a honeymoon phase. Um, and with it being used as self defense, it can be viewed as a mitigating circumstance, but that's where they really have to prove it. They have to prove what was in her mind. And I think they're going to have some difficulty with this case, doing that, because there's just so much evidence that she did this. Like, there's just so much. I'm catching up on the comments. This is yes. All right. And so that's where I'm so glad that the judge figured out that there were that how many different psychologists have been involved in this case. I don't think they're going to add another one. I think they're going to have to go with the people they've already worked with and talk to, because each of those experts costs a significant amount of money. And so, yes. All right. So those are my thoughts. I'm definitely covering this case. I will definitely cover whenever those experts testify. I will definitely react to that. Make sure to subscribe so you can see when I post new videos. I really, really appreciate you all for hanging out. If you're watching on replay, thank you so much. We appreciate the replay crew. If you have questions, make sure to ask. And I hope y'all have a good one.